Then after that, it will be Henry Bansurto who will respond to both. Okay, Attorney Magares.
Magandang umaga po sa akin. Well, our staff is waiting for my slides to look. Morning. I appreciate the presentation of Professor Batongbacal. He was senior to me in law school, so he knows more than I do. But I think our stay in law school overlap. Attorney Bansurto, who was also one of the amicus curiae in another case that we filed before the Supreme Court on the continental shelf, still pending. But that issue, more and more we see the Supreme Court coming to terms with the fact that international is already a daily reality in the Philippines, and it's inevitable for our courts. That's the challenge that Professor Batongbacal has said. The challenge for our courts is to become familiar with the language, with the discourse, with international legal discourse. Because we are already embedded in that kind of discourse, and it will not help if we just keep on denying it. I think the better way, the better approach to answer the challenges of the 21st century is exactly to know how we can use international law. I don't believe that law is irrelevant in the discourse on territory. Precisely, all those lines, all those demarcations, all those boundaries are defined by law. And if we do not know how to address the challenges posed by those lines, by those longitudes and latitudes, we might just lose the battle, the fight for national interest. I was tell my students when I'm teaching another law school. I quote from C. Wright Mills, the tragedy of it's a tragedy that people don't lose values that matter to them. It's even a greater tragedy when they don't know that they just lost something very important, and that's something that we believe might happen to us if we do not seriously look at issues presented to us by RA 95. My slides are on. I will just be discussing the first half because Professor Batongbacal has already discussed the nitty-gritty. Maybe during the open forum, we will have the opportunity to raise the specific issues pertinent to the baselines. But for now, I would like to discuss the interplay between constitutional law and international law in the drafting, in the demarcation of our national territory. Because I really feel that most of the time the fundamental, the most basic considerations are not discussed, which is what the Constitution says about our national territory. Because the fundamental, the most basic law of the land that defines not the extent of the national territory is the Constitution. And of course, the Constitution is not something that exists in a vacuum. It does have interlinkages, interfaces with international law. And sometimes, even in our argumentation, we say that an international legal concept has been constitutionalized, meaning that the language itself of the Constitution has adopted that law. It's in the case of the argumentation we make on the constitutional continental shelf, even if the Constitution itself does not expressly say that when the language of the national territory provision talks about the insular shelf, we know that that provision refers to the continental shelf, because if you refer to the records of the Constitutional Commission, the principal sponsor for that provision has expressly said in the deliberations that he was referring to the legal regime of the continental shelf. Now we have a problem. It's a problem that's been with us for a long time. I guess we are a victim of history. We being a colonized country, we did not have, from the very beginning, a choice about our self-determination. And the result of that is the result that is also the fate of many others that just started to unravel in the 1960s, 20 years after World War II. Slide, please. Now, 1935, the Constitution is very express about the international treaty limits. You see there in the language, there was a very specific discussion of the extent of the national territory that was taken over by a colonizing power, which is the U.S. It says here, the Philippines comprises all the territory ceded to the U.S. by the Treaty of Paris, concluded between the U.S. and Spain on the 10th day of December, 1898, the limits which are set forth in Article 3 of said treaty, together with all the islands embraced in the treaty, included at Washington, between the U.S. and Spain, on the 7th day of November, 1900, and the treaty concluded between the U.S. and Great Britain on the 2nd day of January, 1930, and all territory over which the present government of the Philippine Islands exercises jurisdiction. So it's all there, what Professor Batongbacal has been saying about the Orientalization, what Edward said, called Orientalism. We're a victim of history. It's colonizing powers that decided for us what should be the metes and bounds of our national territory. And it's expressly stated there in the 1935 Constitution, a document of colonization. What does the Constitution of the present say about the national territory? Notice the difference in language. The national territory comprises the Philippine archipelago, with all the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and aerial domains, including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas, the waters around, between, and connecting the islands of the archipelago, regardless of the breadth and dimensions, form part of the internal waters of the Philippines. Take note, the words there. It says, especially the last line, the waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. Right away, you see a fundamental point of distinction between what our Constitution says and what the UNCLOS says. Of course, scholars will say that the UNCLOS will not help you acquire territory because, after all, it's a regime for establishing maritime boundaries. But already, as soon as you pick up your Constitution and looks at it, as soon as you look at the Constitution, look at the national territory provision, the most cursory glance will tell you that the waters around and between connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. We have a big problem, Houston. Because it really means that we need to amend our Constitution if you want to be fully compliant with the requirements of UNCLOS. Because in UNCLOS, you know that there are several legal regimes. You have the territorial sea, it goes all the way to 12 nautical mile rule, and then you have the contiguous zone, you have the EEZ, you have the continental shelf regime, and you have the extended continental shelf regime. And we know that claims of full sovereignty stops at right at the line that demarcates the 12 nautical mile. After that, you only have sovereign rights. Meaning that in general, you have the exclusive right to use. You can use all the resources therein to the exclusion of all other states. But that's different from the sovereignty imagined in our Constitution. because in the Constitution, you see the assertion of full sovereignty. Now there's a question, therefore, if we look at the difference in the language in which the 1935 Constitution and the 1987 Constitution was crafted. Given the difference in language, is there also a difference in the scope of national territory under the 1935 and the 1987 Constitutions? Because apparently there is a difference. In the 1935 Constitution, you see clearly being stated there the international treaty limits established by the Treaty of Paris and the other treaties entered into by the US, especially that with Great Britain. But in the 1987 Constitution, there's no such mention, no express mention at all. The answer is no. Next slide, please. From the proceedings of the Commission that drafted the Constitution, we see that they did intend, by the language they used in the final provision that now appears in the Constitution, that they did intend to include the international treaty limits, the disputed territories of Sabah and Spratleys, including internal waters, territorial seas, continental shelf, and airspace. In fact, it's one of the issues we raised against RA 9552 because it altogether drops Sabah, as well as Scarborough Shoal, because in Scarborough Shoal, Scarborough Shoal now belongs to the regime of islands. It's excluded, it's out of the baselines. While the Kalayaan Island Group has also been defined as a regime of islands. So if you look at the records of the Constitution, there's in fact an intention there to retain the international treaty limits as has been historically handed down to us as a colonized country. Next slide, please. Now, what then are the components of the national territory as discussed in the Commission? You have here the Philippine archipelago. All the islands and waters embraced therein. Its internal waters consisting of the waters around, between and connecting the islands of the archipelago, regardless of the breadth and dimensions. There's some effort, actually, you will notice there's some effort in the drafting of the Constitution of the National Territory Provision to reflect the language of UNCLOS. The archipelago is the very first time you find the mention of the word archipelago in your constitutional history as embodied in a constitutional document. But we maintain our position from the very beginning. Because in the 50s, when the first conference on the UNCLOS was held, Indonesians and the Philippines proposed an archipelagic theory that exactly is expressed here. That this theory embraces the notion of an interconnected and integral whole, so that all the waters embraced therein are part of internal waters, rather than such waters being subjected to a three-level demarcation: the territorial sea, the contiguous zone, the EEZ, and henceforth. Next. It also includes all other jurisdictions which the Philippines has sovereignty over or has jurisdiction. You have Sabah under the Quirón-Base Agreement, Kalayaan Island Group under PD 1596, Cagayan, Sulu, and Cebutu, the Spain-U.S. Treaty of November 7, 1900, though lying outside the line described in Article 3 of the Treaty of Paris. Partly the Americans and the Spanish forgot about Cagayan, Sulu, and Cebutu, so they had to meet again and expressly contain jurisdiction over these islands in a treaty, which was subsequently signed in November of 1900. You also have the Turtle Islands and Mansi Islands, which is covered by the agreement between the US and Great Britain. And Professor Batongbacal has talked about that. So now you have to both components pertain the territorial sea, the fluvial domain, the aerial domain, the airspace, seabed and subsoil, the insular shelves, and other submarine areas. So remember that. Next. So clearly the intent was not to limit the territory to the Treaty of Paris. The language of the national territory really embodies this vision of an archipelago that's interconnected by history, by culture, by political elements of the Philippines as an emerging state.